Okay, good morning, everyone. It is Wednesday, March 23rd, 2022. It's 9:30 a.m. We're in conference room 430, and this is the Committee on Corrections, Military, and Veterans. We're also joined via Zoom, should folks want to join us as well. We have 3 bills on our agenda, and we're going to jump right in. First up, we have Senate Bill 2091. And our first testifier is PSD, and PSD is testifying, providing some comments. Up next, we have testimony from the Hawaii Paroling Authority. Good morning.
Good morning, Chair Ono. Vice Chair Ganaden, can you hear me?
We can hear you. We can't see you, though. There you are.
There I am. So aloha and good morning, Chair Ono, Vice Chair Ganaden, and committee members. My name is Fred Hyun, Chair of the Hawaii Paroling Authority. I stand on my previously written testimony and offer the following concerns regarding SB 2091 SD1. In 2017, the pardon process was streamlined, noting that in years prior, there was no statutory requirement for the AG's involvement, although they were involved in investigations. Pardon investigations are extensive and thorough before it's presented to the parole board, followed by public safety. Please remember that pardon consideration is for post-conviction relief, having demonstrated successful rehabilitation for a significant amount of time, as well as taking responsibility for the stated offenses. This includes everything from petty misdemeanors to felony convictions, incarcerated or not. In recent discussions with the Honolulu Prosecutor's Office, HP is more than willing to notify counties upon receipt of any application. Please remember that the AG's office is the legal arm of the executive branch, and pardon recommendations to grant or deny are forwarded to that office before going to the governor's desk. Thank you for the opportunity to testify, and I will be and am available for questions. Thank you.
Thank you very much. We have testimony from the Crime Victim Compensation Commission in support. And we have testimony from the prosecuting attorney from the City County of Honolulu. Good morning. Thank you for joining us.
Good morning. Good morning, Chair, Vice Chair, member of the committee, Deputy Prosecutor Tricia Nakamatsu. On behalf of the Honolulu Prosecuting Attorney's Department, we are in strong support of this bill. It is part of our 2022 legislative package, and thank you so much for hearing it, Chair. We understand that you also heard the companion bill previously, and this is a crossover after the crossover. This is the Senate bill that has made it all the way through the Senate and now and back in the House. We would like to emphasize how important this bill is for the benefit of victims. If you can imagine what it would feel like to be a victim of, and perhaps I can't even imagine myself, what it would feel like to be the victim of a crime, sometimes violent crimes, very personal, domestic violence type crimes, could be essentially anything. And to have gotten through the entire criminal justice process, to have felt whatever relief or other feelings you might feel once a conviction is gotten, and then years later to hear that the person was completely pardoned and not have even been asked how you feel about it, not have been given a chance to give any input whatsoever, not even known that an application was submitted. That is what these victims are going through when the pardons are, and of course, I'm sure the range of emotions varies widely. Perhaps some it really doesn't faze them, and some it could potentially re-traumatize them. But really all we're asking for is a statutory process requirement that the prosecutors and through the prosecutors, the victims be notified when these applications are submitted to ensure that victims have a chance to provide input. Now, what weight that is given in the process, given the specific focus of the paroling authority's investigation or the specific focus of the governor's decision-making, that is not affected or changed in any way by this. It would not be changed by the bill. It simply allows the victim to say something, so they know and they have a choice to say something. And also our intent is not to raise concern or alarm about the thoroughness or the rigors of their investigation process. We're sure that's not the point here, basically. just that we do feel the process would be improved, and certainly for the victim, it would feel like more of a complete process if they're guaranteed the right to have a voice, as they do in many other steps prior to sentencing, conviction, parole, furlough, things like that. But even more so in this case, they've gone through the entire process. There was a conviction, and now a pardon essentially has the potential to wipe that all away. The offender is not the only one who is affected once a pardon is granted. And we just like the legislature to ensure that the victims have a say, have an opportunity to say something. Now, we will point out that in our testimony, we note that the language of this particular bill, the original version, which is very similar to the current, was drafted in partnership with the Hawaii Patrolling Authority and Department of the Attorney Generals in 2020. But that even was the tail end of a very long process, which began in 2014, when our office, actually a case was brought to our attention where the victim was very upset about having no idea that in this case was a commutation, a pardon commutation was going to be considered. Apparently they did, in hindsight, they realized they got a call from the Attorney General when the Attorney General was looking into things. They did not know who they were speaking to. They did not know what it was about. And well, so suffice to say, they were very upset when they found out about it in the end. So from 2014, then it was a long back and forth between our office and the Attorney General's about whether we could implement some kind of system through memorandum of agreement or something or the other. At the time, the Attorney General opined that everything about the application was confidential, that the victims, the prosecuting attorneys, no one was allowed to know anything about it until the governor approved it. That opinion, we believe, has since changed. And then at that point, we started talks about perhaps maybe doing an MOU. And they said, no, an MOU is not going to be sufficient. You need a constitutional amendment. So in 2016, we went in with bills for a constitutional amendment and in the as well as a statutory fix. Come to find, after extensive research, constitutional amendment is not necessary. And that's why our bill actually goes into some detail about the Constitution provisions for other states, just because that was part of that whole process. But this just goes to show that from one administration to the next, from one attorney general, from one perhaps a change in leadership at the patrolling authority, they can determine and they just can change their opinion onto whether a victim can get notice or not. Clearly they can do that, as it is right now without a statute in place, without anything in writing to say that, yes, you do need to inform them and allow them to speak. So we just would beseech the legislature to please pass something on behalf of the victims to allow them to have that voice and allow them to have notice. We are entirely open to the details of the process, the procedure, what the statute would say, whether there's deadlines. We tried to submit a proposed HD1, which we feel would meet some of the concerns that were briefed, that we interpreted previously, as far as not wanting to hamstring the polling authority's process and so forth. So that's what all of these little changes are intended to do. And if you have any questions, we are absolutely available.
Thank you. Thank you for joining us. We have further testimony from the County of Kauai Office of the Prosecuting Attorney in support. And we have testimony from the ACLU. Okay, and they testified in opposition. We have testimony from one individual in support, and it looks like testimony from Mothers Against Drunk Driving, Hawaii, and they also testify in strong support of this bill. Members, any questions? Senate Bill 2091.
To Mr. Hyun.
Vice Chair, yes.
Right here.
Yes, sir.
Good morning. About how many individuals receive pardons annually, just to give us a background?
Well, last year, what was submitted was 21 pardons recommendation to the governor's office. Now, be advised that once the investigation is completed, the parole board receives the pardon recommendation, whether to grant or not grant. That is also then submitted. Once the parole board has reviewed and rendered its recommendation, it goes to the director of public safety, who either concurs or not concurs, and then it is forwarded to the Attorney General's office for their review, because they are the legal arm of the governor, and then it goes to the governor's desk to grant or not grant. So last year, based on our statistics and annual report, 21 pardons were completed and submitted to the governor's office.
Of those 21, how many were granted? How many individuals were given a pardon?
We don't really have a hard figure on that, because sometimes a decision may take years, not months. This process is not an automatic process.
Can you give us a rough estimate, like percentage-wise, from those submitted, approved by you folks, DPS, and Office of the Attorney General that are eventually granted?
I would have to get back to you on that as far as any firm numbers, but from hearings on the board that I've presided on, which we do every month to review pardons as well as other matters, we grant or recommend perhaps less than half of those pardon applications that are submitted.
Thank you.
Thank you. Members, further questions? Rep. Kobayashi.
For prosecuting attorney and for parole authority, the bill has what looks like 3 mentions of within 30 days and at least 2 mentions of 45 days. Is it possible to meet these time limit requirements?
I'll speak first. As far as the timetable, the paroling authority really doesn't see a necessary need for the timetables, and that has been expressed to the prosecutor's office. The period of investigation can take anywhere from 4 to 6 months. That's just on the paroling authority side. So to have these restrictions, to me, I've posed it to the prosecutors. That would be on them. We can provide notification, and they have all the time that they need to solicit any testimony or input they want into the investigative process. So I have no problems with the time restrictions, so long as any submissions are done before the investigation is completed.
Thank you.
And Representative, if I may add, in speaking with the paroling authority, and I believe it's consistent with what Mr. Hyun has also just indicated, the timeline that the specific periods that are in the bill, even as written, would not conflict or hamstring their process at all. The 45 days is basically just for us to send the basic information like their name, which is on the application, why they're requesting the pardon, for which charges. So basic information that we could follow up and then find the victim and find our own files on the matter. In our proposed proposed HD1, we actually are open, and if it is all right with the paroling authority, to decreasing that first 45 days to 30 days, so that the entire process would basically only take 90 days. 30 days for them to let us know who and what they're requesting. 30 days for us, our prosecuting attorneys, to find and notify the victim. And then an additional 30 days for the victim to decide and to ultimately submit something if they wish to do so. So 90 days altogether. And that change was suggested by our office because the investigation, when we were looking at the paroling authority's timeline, could be done possibly in as little as 120 days, I believe. So we just wanted to make sure there's no possibility of us holding up their wanting to do a hearing on the matter.
Thank you.
Members, further questions? Senate Bill 2091. Thank you, everyone. Thank you for joining us.
Oh, and I'm sorry,
Oh.
Chair, I'm sorry. I did speak with the Hawaii State Coalition Against Domestic Violence. They said that they submitted testimony to you just this morning. And so to look for that if it is still possible to consider.
Okay, thank you. Vice Chair's office will take note of that. Yep, Anita, and then can also just see if it's circling somewhere. Okay, up next, we have Senate Bill 2305 relating to the Comprehensive Offender Reentry System. First up, we have PSD testifying in support. We have the ACLU support, Common Cause Hawaii support, and the Community Alliance on Prisons. Okay, also in support. That's all the testimony I have for Senate Bill 2305. Was there anyone else here wishing to testify on 2305? Thank you. We're gonna skip questions, members, since it looks like there's no one to pose those questions to. Up next, we have Senate Bill 3087, and we have the Department of Defense testifying in support. And Haima also, well, Haima, good morning if you're here. Senate
Good
Bill
morning,
3087. Good morning.
Yeah, good morning. My name is Holly Reyna. I am a public relations specialist with HIEMA, and I'm testifying on behalf of Administrator Myers. The organization stands on its written testimony in support of this bill, which is also part of our governor's LP, and I'm available for any questions.
Okay, thank you very much. That's all the testimony I have on Senate Bill 3087. Is there anyone else here wishing to testify on Senate Bill 3087? Okay, members, questions? Okay, if not, we are going to roll right into decision making. Thank you, everyone. First up on our agenda, we have Senate Bill 2091. The chair's recommendation is to pass this out with amendments. We're going to take the amendments provided by the Honolulu prosecuting attorney. And there was some discussion, thank you, Rep. Kobayashi, about those dates. As we kind of reviewed the bill, we thought it might be best that on page 2, subsection B, that instead of the 30 days, we're going to ask the paroling authority that they will transmit the application information to the county prosecuting attorney offices upon confirmation that it is complete and meets HPA requirements for review. And that'll be in place of the 30 days, within 30 days. We also have on page 2, subsection B, we're going to remove the reference to providing notarized character affidavits. And that's that the language is consistent with the first part of the section. We'll make further technical and non-substantive amendments. I believe this bill already has a defective date, correct? But I was quite compelled by the testimony from the other members. Oh, correct. We'll take the draft from the Honolulu prosecuting attorney's office. Plus those 2 changes. Good catch. Correct. The draft that was provided by the Honolulu prosecuting attorneys, and that was in their testimony, members. Okay, questions, comments? Okay, Vice Chair 2091. Oh, sorry, Rep. Kobe. Okay, with amendments.
Members, the recommendation of the chair is to pass SB 2091 SD1 with amendments. Chair and Vice Chair vote aye. Representative Bronco.
Aye.
Representative Kobayashi.
Aye.
Representative Kong is excused. Representative Morikawa.
Aye.
Representative Tarnas.
Aye.
Representative McDermott is excused. Chair, the recommendation is adopted.
Thank you, members. Up next, we have Senate Bill 2305. This really is just a housekeeping measure. It's a typo that was put into the Oversight Commission's statute a number of years ago when it was established. This has a clean date, and that's the intent. So the vote, Vice Chair, the recommendation is to vote on this as is. Members, questions, comments? Okay, as is 2305.
Members, the recommendation of the chair is to pass SB 2305 unamended as is. Chair and vice chair vote aye. Are there any reservations? Are there any members voting no? Noting the excusal of Representatives Kong and McDermott, chair, the recommendation is adopted.
Thank you, members. Senate Bill 3087 is the last bill on our agenda. This just simply moves some of these chapters in our HRS. Chair's recommendation is to pass as is. It has a defective date currently of July 1st, 2050. Questions, comments, members? 3087 as is. Okay, Vice Chair.
Members, the recommendation of the chair is to pass SB 3087 SD1 HD1 as is unamended. Chair and vice chair vote aye. Noting the excusal of Representatives Kong and McDermott, are there any members voting with reservations? Are there any members voting no? Chair, the recommendation is adopted.
Thank you, members. We are adjourned.
Good morning, all. Welcome to the Committee on Corrections, Military and Veterans Affairs. My name is Sonny Ganadin, Vice Chair. To my left is Representative Takashi Ono, Chair. As per custom here at the House, I will be running the resolutions today. First on the agenda, we're just going to roll right into it, is HCR 8 and HR 5. We're going to be hearing currently, requesting the display of the prisoner of war and missing in action flag at the state capitol. Today testifying, we have Mike alluded in support. Are you here? I don't believe we received any late testimony on this one. Is there any other organizations or individuals here to testify on HCR 8, HR 5? Okay, moving along. HCR 12, HR 10, urging the judiciary to assign one judge for the Hope Probation Program. Testifying, we have the Department of the Prosecuting Attorney of Honolulu.
Good morning, Vice Chair, Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. Department stands on its written testimony in support. Would like to note to the committee and reassure the committee that the department is still working and meeting with the judiciary to ensure that Hope remains a viable program at the judiciary and due to its proven track record to reduce recidivism. Thank you.
Thank you. We also have here Judge Robert Mark Browning, Chief Judge of the First Circuit Court. Are you here? Or someone here from the judiciary? That testimony is in opposition. Members, hoping you have an opportunity to review it. It discusses some of the staffing issues that the judiciary has been facing over the last several years. Also, we have with late testimony, Nico's Loverend, Grants and Advancement Manager from Hawaii Health and Harm Reduction Center with comments. Are you present? Hearing none. Are there any other organizations or individuals here to testify? HCR 12, HR 10.
Yes.
Oh, the Carrie Ann Shirota from the ACLU.
I apologize. I just want to make sure, is this HCR 12?
Yes, it is.
Okay, I apologize for being a few minutes late. Yes, I would. I did submit written testimony. It was late though. So aloha, Chair Ono, Vice Chair Ganadin, committee members, Carrie Ann Shirota on behalf of the ACLU of Hawaii. This is in regards to HCR 12 requesting the judiciary to assign one judge for the whole probation program. While we acknowledge retired Judge Ahm's intention to experiment with changes to probation to improve outcomes, we have concerns about this particular resolution. The evaluation that was conducted in 2007 compared to whole probation to standard probation did show positive outcomes, but that evaluation is dated, and there has not been a cost benefit analysis of Hope compared to standard probation, compared to alternatives to both programs, and really matching dollar for dollar to see if it is the best use of resources. Other states have enacted probation reforms and have reduced the length of time on probation. It is important to note that Hawaii, according to the Pew Report, has the longest length of probation terms in the United States. The average is 59 months. The longer that someone is on probation, there is a greater likelihood that it may result in revocation for technical violations. The cost to incarcerate someone under SWIFT and certain sanctions is $219 a day. You multiply that by 365 days over the course of time, that's over nearly $80,000 a year. When you look at the number of people who are revoked, in 2022, we had, in January 2022, there were 406 persons on probation revoked in our jails. Now, when we look at years past, this is really important if we look at the demographics. In 2014, we had individuals violation probation. Sorry, I'm trying to flip through my documents here. We had 284 persons revoked in 2014. In 2017, probation revocation went up to 436, and there was a peak in 2019 of 516. Of that, the data doesn't show how many people were revoked under whole probation. However, in 2022, we have 405 persons revoked in the midst of a pandemic. So if you look at the long history and the demographics, we actually have been increasing the number of people who are revoked for violations rather than investing in other proven probation reforms such as earned time credits, alternatives to incarceration for technical violations, particularly for drug use. So we ask that before we assign a judge solely to this court, before we invest more money into incarcerating people, that we really do a true cost benefit analysis and then decide how do we best utilize taxpayer dollars. Thank you very much for the opportunity to testify.
Thank you, Ms. Schroeder. Are there any other individuals or organizations here to testify on HCR 12, HR 10? Members, questions? Okay, moving on. HCR 16, HR 15, requesting the Judicial Council to appoint a committee to review and recommend revisions to the Hawaii Penal Code. We have 16 on-time testimonies. Rod Miley, the Administrative Director of the Judiciary State of Hawaii, are you here? No. Anybody from the Judiciary? Charlotte Carter Yamauchi, Director of Legislative Reference Bureau, right here in the building with comments. Not present. Nikos Leverins, Grant and Advancement Manager, Hawaii Health and Harm Reduction Center. Not present. Are there any other organizations or individuals here to testify regarding HCR 16 or HR 15?
Yes, Vice Chair. Vice Chair Carrie-Ann Shirota, on behalf of the ACLU of Hawaii, we did submit written comments. It is late. We want to offer comments. When we look at the language of the resolution, it's based on this premise that essentially judges are using their discretion inappropriately, capriciously, in violation of our laws. My understanding of our process is that every so many years, we already have a penal code commission that comes together to review whether or not changes need to be made. And I saw that there was a draft resolution in 2015, some years ago, that was very similar. So the first question is whether we need to have this commission in the first place at this point in time, given other priorities and other needs within our community, because it would require governmental stakeholders, community to come together, utilize their time, and is that the best use of resources? So the question is whether this is needed at this point in time, when there is a process already to do a penal code review. The second point we'd like to make is that if you are going to convene a penal commission, that it be balanced. Right now, based upon the composition, the way that it is worded, it is skewed towards law enforcement and not looking at the larger picture of criminal legal reforms in particular, which is the trend in many, many states, not only for moral and ethical reasons because of pretrial, we're locking up poor people, but also because of a recognition that we have severe overcrowding and that there are mechanisms and strategies that we can utilize to decrease our carceral population. So I'd like to make some recommended amendments if this moves through. And again, we're questioning whether this is needed at this time. The prior resolution in 2015 allowed for the City and County of Honolulu prosecutor to have essentially an equal vote as the other prosecutors within each of the counties. This particular resolution would allow the Honolulu prosecutor to be the chairperson. We believe that that is not fair in terms of geographic diversity. If there's going to be the prosecutor, all prosecutors from each county should have equal vote, equal voice. And the commission, if convened, should elect a chairperson rather than having it designated. We also ask that you strike the representative from the police department. We believe that that's outside of their purview of duties. We recommend that you expand psychologists, social workers to include healthcare professionals with experience in behavioral health, harm reduction, substance use treatment. We also ask that we have on-par representation, geographic, between the public defenders and prosecutors. If we have a prosecutor from each county, we should have a public defender. While public defenders is a one agency statewide, there are differences and nuances within the practice from circuit to circuit, from Maui to Hawaii to Kauai. We'd also recommend that to advance criminal legal reforms, which is something that this legislative body has supported, we recommend at least 2 representatives from criminal legal advocacy organizations, representatives from institutions of higher learning in Hawaii with experience and expertise in crime, corrections, and criminal legal reform. We also think it would be a benefit to this body to have a representative from the Criminal Justice Research Institute, which is attached to the judiciary and is mandated to provide data to drive decision-making. And last, we also ask for a person with experience in restorative justice practices, as well as individuals who are justice impacted, who have experience about what works and what does not, to build a healthy and safe, thriving community. Thank you for the opportunity to testify. Mahalo.
Thank you so much, Ms. Shirota. Is there any other organization or individual here to testify on HCR 16, HR 15? Members, questions? Moving on. HCR 57, HR 51, expressing support for the naming of a United States Navy surface combatant ship after fireman, second class and Congressional Medal of Honor recipient, Teleforno Trinidad. We did not receive any testimony on time. Is there anyone or individual or organization here to testify regarding HCR 57 or HR 51? Hearing none, we're going to be moving on. HCR 91, HR 85, I'm going to read it out. Declaring over-militarization to be a threat to the security of Hawaii and the international community and urging prioritization of humanitarian aid in the United States response to the Ukrainian conflict and increased efforts to strengthen international nuclear proliferation. We have 2 individuals who submitted testimony on time. And I believe we have 14 individuals who submitted in the last evening. On time, we have Wally English. Are you here? Stanford Carr, Stanford Yee. Are there any other individuals or organizations here to testify regarding HCR 91, HR 85?
Hello, I am.
We have David Mullenix, an individual.
Yes.
Go ahead.
Well, as our Revolution Hawaii, we
Our Revolution
stand in
Hawaii.
support of this resolution. And also, I would add, whereas Joe Biden should call for an immediate ceasefire in Ukraine. He has that power and ability, and he should be doing so because war is no good for any of us. So stand in strong support of this resolution. Thank you very much.
Thank you. Any other individuals here to testify regarding HCR 91, HR 85? Members, any
Yes.
questions?
Can
Oh,
I testify if I haven't signed up?
We'll allow it. Ms. Brown?
Okay. Yes, I am testifying in support for HCR 91. And I echo the previous testifier that war is no good for anyone. Thank you.
Thank you. Any other testifiers for HCR 91, HR 85? Members, any questions? Moving on. HR 95, urging the Hawaii congressional delegation to take the necessary action supporting the reorganization of important military assets and property for increased efficiency and effectiveness. I believe we have 2 late testimonies, one from the Military Affairs Council in opposition. Is there anyone here from the Military Affairs Council? And we have another bit of testimony from Our Revolution Hawaii in support.
Yes, hello?
Yeah, Mullenix, go right ahead.
Yeah, actually, I'm sorry, I'm actually confused by this resolution, and I just asked, the Army themselves asked to close one of their bases here, and I couldn't remember if it's Schofield or Fort Shafter, because they don't need it, and it's a waste of resources for them. The Army does not need or cannot use a base here to deploy their military. So I'm kind of questioning, is this, anyway, I'd like to ask McDermott or whoever, is this trying to close down this base that the Army said they didn't want? And if that's the case, I definitely support that. So is that a question that can be answered to me, or is that something you do later?
We're not sure, Mr. Mullenix. The author of the resolution is not present with us.
All right. So that's my thing. If they're trying to close down a base that the Army wanted to close down, then I totally support that. But if they're not, then I don't. So it's a very confusing bill. So I'm sorry if I'm having a confusing testimony. Maybe I'm just doing comment. Maybe that's better. Anyway, thank you so much for I hope I'm not wasting your time. Thank you.
No, and just thinking procedurally, ordinarily, we don't have this sort of back and forth. I think that you kind of pose the question and then you can ponder it and redirect it. So for future reference.
Okay, thank you. Sorry.
No problem. Members, any questions? HR 95. Now hearing HR 182, requesting the Department of Land and Natural Resources to conduct public forums to solicit input from the community regarding the lease of state lands to the military. My apologies to the members and to the public. This was a late submission, so both members and the public really didn't get enough notice as they should have regarding this hearing. We hold on. We did get testimony from the Department of Land and Natural Resources, Hawaii County Council, and the Military Affairs Council. I see here on the screen the Department of Land and Natural Resources.
Yes. Good morning, Vice Chair, Chair Russell Tsuji for the department. We respectfully oppose this measure primarily because we believe that there's adequate public commentary period during the extensive environmental review process. Permitting, in this case, a conservation district use permit would be applicable for places like PTA on Big Island, as well as a leasing process. And so we feel that the public, this reso is kind of redundant of what's already built in the law. Thank you very much. If you have any questions, I'm available.
Thank you. I believe we also have testimony from Hawaii County Council, Maleka Goro Inava, Council Member, District 8, North Kona. Present. That is testimony in support. We have testimony in opposition from the Military Affairs Council. Anyone present? We have further testimony from 24 individuals. Out of respect to the people that were doing this hybrid system who have showed up here in person, is there any individual here to testify regarding HR 182 in person here?
Aloha mai kako, representatives, mahalo. I am Hinale Moana Huangkalu, and I testify in support of this resolution with one caveat, and that is that I would like to encourage the Department of Land and Natural Resources to pay close attention to the Native Hawaiian community. Native Hawaiian community makes up 6% of the population of Hawaii, which is very similar to the population of that of the US military here. And with 14 primary military installations, it is essential that there be a greater effort to make sure that public has a different level of input. It is akin to going door to door when campaigning. It is akin to making a personal outreach to ensure that the voices of our community are heard when it comes to important matters such as this. And in closing, I would like to also encourage all of you that this is not about being anti-military, but this is about being very pro-Hawaii as well as pro-Kanaka, to support the initiatives, to support things that uplift our people of Hawaii, especially the Native Hawaiian community. Mahalo.
Thank you so much. Are there any other individuals or organizations here to testify regarding HR 182?
Aloha. My name's Emily Marie Gambing. I'm born and raised on the island of Hawaii in Kailua Kona. I'm now a resident here in Oahu. I am in support of HR 182. I'm honored for the opportunity to speak about military presence here in Hawaii. I wrote a poem, if that's okay, to just speak about how I feel about this issue, and it's just a very beautiful, powerful poem that I feel like I wanted to share today. Envision fruit trees at every corner, kids of every color, a plethora of herbs, holistic healing power. Tending to the aina, planting our seeds everywhere we wander, eating from the land and drinking clean water, sundazing our pineal glands, tapping within for all the answers, staying aligned so we don't project on our brothers and sisters. We learn by listening to our elders, ancestors, divine creator. Always mahalo ke okua for birthing Mother Nature. United and rooted, we're open to evolution, laughing and dancing to the beat of community. I envision you and me, our kids being friends, if you're walking on the streets, neighborhood watches rather than military, no political standing, just human beings. This is our birthright. Everything should be free, like living spaces are essential needs. There shouldn't be a Hawaiian homeless in their own homeland. I affirm for greater. I don't believe the military malama the aina. Water is life, food security is important. They're destroying our aina for military practices. We need to take our land back. Mahalo. Again, my name's Emily Marie. I'm a Keiki o Kaina. I'll always fight for the preservation of the land and Hawaiian culture. So I'm in support of HR 182. Thank you.
Lovely. Are there any organizations or individuals testifying regarding HR 182 on Zoom? Ms. Brown.
Good morning, committee members. My name is Shanti Brown. I live in North Kona. I was raised in Saukohala in Waikoloa Village, which is in proximity to the former Waikoloa Maneuver area and Pohakaloa training area. Please support HR 182. Over the years, many citizens and groups have shared concerns about depleted uranium and lack of remediation on state lands leased to the military. I submitted written testimony for you all, which I was going to add to and read here. I'm going to speak a little bit from my heart instead. I feel like we are at a point of time where Hawaii leaders need to reflect on what it means to be in a position of power. And the state constitution, you all swore an oath to conserve and protect Hawaii's natural resources, just for the benefit of the people. Kind of in going along with what the Department of Land and Natural Resources brought up, is that there are some pathways to for citizens to give input, but how accessible are they for people? And are you all following what we've brought up as citizens? Because we've continually come and testified and written in with our concerns, and what are the outcomes from state agencies and leaders that show that you all listen to us and that you are taking your power in consideration. We shouldn't have to put ourselves out there so much to be heard. We come to you. You should listen and follow our advice and come to us maybe. So yeah, I support this, and I hope you all can give us more space, however space that we can, including in this resolution to have our voices heard and follow through on listening to us by giving us some actions that show that you listen to us. Mahalo for your support.
Thank you, Ms. Brown. Any other individuals appearing via Zoom? Hearing none. Are there any other individuals here in the room here to testify regarding HR 182? Members, any questions? Vice Sheriff has a question to the Department of Land and Natural Resources. Mr. Suji,
Yes, yes, sir.
what kind of processes has the department undertaken as a result of the Ching versus Case Supreme Court decision in 2019, which discussed essentially various state failures by the state to have oversight of these military lands?
The Ching case, actually, actually the trial court had revised its order to make it more in a recommendation format versus mandating certain things. Right now, we are looking at the lands, and I got to tell you, I've been out there at PTA. The lands are taken care of quite immaculately by the federal government, much better than most of our leases in the state of Hawaii by private entities. They do a lot of environmental studies and work and archaeological studies as well. As far as inspections, we are scheduling one shortly coming up in the summer after this legislative session for staff to go out there. And I believe the plaintiffs will be allowed to attend as well. As far as environmental public commentary period, like I said, for retaining those lands to the extent that they're applying for a lease, if they're actually asking for a lease, and not all of them are asking for a lease, some majority are, they will have to go through the environmental review process. Like I said, the EA and EIS process, which has extraordinary opportunity for the public to comment. In particular, Puakoloa on the Big Island is conservation land, so that would also go through the Board of Land and Natural Resources through a conservation district use permit application, which is separate and distinct from the lease. So there'll be that opportunity of public comment period, in addition to open public comment to comment before the board, before the permit is issued. Subsequent, only if the permit is issued, they will proceed to the next step of a lease, and that would also be done in an open meeting. So we believe that there's a lot of public commentary period on this one before the board makes a decision on whether, if it was to be a lease, to grant or deny the lease.
What kind of
Did I answer your question?
It did. Thank you so much. What kind of process was entered into between the state and branches of the United States military when these leases were entered into? If you know, it's okay.
What kind of what again?
What kind of process was entered into with regards to, say, public comment or a conversation regarding these leases was entered into when they were first originally created?
Talking back when they were entered into in 1960 something.
1965.
Yeah. I believe they went to the land board, and the land board would have been open to the public at that time. But as far as what was transpiring before it went to the land board, I'm not sure, because obviously the conservation laws or EIS and EA laws were not in place at the time. Conservation district law came into play, I think, in 1980s or so. If you're asking if those applied at the time, no, probably not. the lease in particular, and most of the military leases that I've seen are signed off specifically by the Attorney General, not a Deputy Attorney General, but the Attorney General, and was negotiated by the Attorney General himself with the Pentagon. That's my understanding, sir.
Thank you so much. Members, any further questions? Representative Kobayashi.
For DLNR,
Yes, sir.
I think the aim of this resolution is to try to get some sort of feel for how the community wants the land to be used prior to any application for lease extension. Is there such a mechanism currently?
Currently, the leases are in place. They're not expired.
Oh, I thought that there was the expiration in 2029.
Yeah, it's coming up. So currently, at this time, the leases are in place, and the federal government is utilizing those lands for military training, etc.
I see. No,
It's
I
not.
think,
It's not like the state has those lands in its possession or control at this time. It's under lease.
I agree. No, I think that what the resolution seeks to put into place is a sort of like an early discussion about what the community feels about the current use of the land.
And actually, if I may, for Pascualoa, the EIS process has started. The public commentary period has started.
Oh, I didn't know that.
Yeah, and so, and in fact, all of the Army leases, in fact, I would say, they are in the heat right now, currently, actually quite into the EIS process right now for all of the Army leases in the state of Hawaii, including Makua. And the ones on Oahu, I think in Kahuku and Paumoho. The ones that I think are a little bit behind and I haven't seen them start the EIS process is other than the Army, all Army statewide have started. And they're already in the public commentary period. Air Force tracking station at Kahuku, I haven't seen them start, or the Navy Pacific Missile Range in Kauai has not. I have not seen them start. But really, those are the primary bases we're talking about.
Thank you.
Any other questions from members? I'd like to note some of the testimony that that we received from Professor and Dean of the School of Hawaiian Knowledge, John Kamakawiwo Ole Osorio. He notes that from the first decade after the U.S. takeover of Hawaii in 1900, the United States has never had a shortage of land of its choosing, being granted more than 100,000 acres for military use through presidential executive orders and securing long-term leases of more lands under territorial and state control. Even Hawaiian homelands at Lualale and Belos very much at will. Department of Defense utilization of these lands have rarely included a sense of stewardship or care, and almost never a plan for returning lands to the state of Hawaii or the Hawaiian people. An action to clean up after decades of neglect and active destruction have only come when compelled by law. As we have seen in the Navy's response to drain the fuel tanks at Kapukagi, Moanalua, the U.S. military does not respond to public pressure or seems to possess a sense of its responsibility to the near million residents of Oahu that considers its mission and its own needs. That said, short recess. Recess for decision making. reconvening the House Committee on Corrections, Military and Veterans Affairs for decision-making on our resolution calendar. HCR 8, HR 5. Recommendation of Vice Chair is to pass. No amendments. Are there questions, comments, concerns? Chair, the recommendation is to pass HCR 8, HR 5 unamended,
As is.
as is.
Members, we're voting on HCR 8, HR 5. Chair's recommendation is to pass as is. Chair and Vice Chair vote aye. Representative Bronco?
Aye.
Representative Kobayashi?
Aye.
Representative Kong, excused. Representative Morikawa?
Aye.
Representative Tarnas?
Aye.
Representative McDermott is excused. Chair, the recommendation is adopted.
Thank you. Members, after healthy discussion, the recommendation of Vice Chair is to defer HCR 12, HR 10. Are there any questions, comments, or concerns? Moving along. Regarding HCR 16, HR 15, after conversation, the recommendation of Vice Chair is to defer. I think that this requires much more conversation regarding with various members of the government and advocates. Questions, comments, concerns? Moving along. HCR 57, HR 1. Members, we did not receive any testimony regarding this resolution. Vice Chair's suggestion is to defer. Questions, comments, concerns? Moving along. HCR 91, HR 85. After brief conversation with members, Vice Chair's suggestion is to defer this measure. Questions, comments, or concerns? Moving along. HR 95, urge. The suggestion of the Vice Chair is to defer this measure. Questions, comments, or concerns? HR 182. We received some fairly heartfelt testimony. Thank you so much to the individuals that showed up here in person to talk to us about this issue, which will be presented to the state of Hawaii and the community for several years to come. It is Vice Chair's suggestion to pass this along. Questions, comments, concerns? Representative Tarnas.
Thank you. I think that the National Environmental Policy Act process is a very effective tool to gather public information and public comment. And I know that they've been doing that on our island right now with Pohakalo Training Area. And they are in the middle of that process with other federal military land leases. You know, with that in mind, I recognize that this calls for additional opportunities to have the community give input. And so I will vote with reservations, just noting that the NEPA process, I think, does provide that opportunity. But out of deference to you, the introducer, I'll vote yes with reservations.
Any other members? Questions, comments, or concerns? The recommendation is to pass HR 182 as is, noting the reservations of Representative.
HR members, we're going to vote on HR 182. Am I good to go?
Yes.
Okay.
Sure.
HR 182, Chair's recommendation is to pass as is. Chair and Vice Chair vote aye. Rep. Bronco.
With reservations.
Rep. Kobayashi.
Aye.
Rep. Kong is excused. Rep. Morikawa.
Reservations, please.
Rep. Tarnas.
Reservations.
Rep. McDermott is excused. Chair, the recommendation is adopted.
Thank you so much. And with that, this hearing is concluded. Thank you so much for all who attended.